Our first panel discussion today will explore the Victorian Government's response to recent riots in youth detention facilities. Should children ever be transferred to adult prisons? Should they be managed by the Department of Human Services or by the Department of Corrections? Are the concerns of human rights lawyers justified? And why recently, I think it was on the 11th of May, did the Supreme Court of Victoria rule that kids must not be held in adult jails? And looking into the future, what sort of youth detention regime do we want to build and work to? The organisers of Talking Justice sought to get a range of perspectives for this panel. They approached the Department of Justice, the Department of Human Services, Victoria Police, the local state MP and the Herald Sun. And unfortunately they were all unavailable to participate today. Now, these issues do affect central Victoria. You've got Malmsbury Youth Detention Centre just down the road. And I think we do have to be very clear-eyed when we have this kind of discussion. Back in January, 83-year-old Bendigo pensioner Herman Kleinhut was heading off to visit his wife's grave. 4 teenagers, part of a group of 30 who'd just escaped from Malmsbury following a riot, carjacked Herman, pushed him out of the car and left him on the side of the road. I think this group of 4 of about 30, as well as carjacking, were involved in aggravated burglaries, armed robberies, using weapons such as knives and baseball bats and stealing cars before they were arrested. Now, we're going to be talking about what the best public policy is around juvenile detention, but we acknowledge the serious impact of crime on victims and people like Herman, people in the Bendigo community here. Now, our first speaker is Claudia Fatone, and Claudia is the Executive Officer of the Fitzroy Legal Service, a position she's held since 2013. She's also a board member of the Victoria Law Foundation, and she's also a director of Cricket Victoria. And Claudia is also a mentor with the Assister Mentoring Program, which matches young women with volunteer mentors. Now Claudia is going to speak about some of her clients and the recent litigation that saw the removal of children, I think it was on May the 11th, from the Grevilla unit at Bowen Prison. Would you please make Claudia welcome?
Thanks, Damien. I too would begin by acknowledging that the city of Greater Bendigo is on the Dja Dja Wurrung and Turrangung country, whose ancestors and descendants are the traditional owners of this land, and pay my respects to elders past and present and to any First Nations people who may be in attendance today. So the question, as Damien has outlined, is youth crime. Should we treat young people, should we treat children in detention the same as adults? So interestingly, we treat children under 18 different to adults in a whole range of other factors of our community lives. Drinking alcohol, driving and voting. So why should justice be any different? I'll come back to that point a bit later on. On the 2nd of December 2016, the Fitzroy Legal Service, in conjunction with the Human Rights Law Centre, lodged a challenge in the Victorian Supreme Court seeking the removal of young people that were being held at the Grevilla unit of the Bowen Adult Prison. Bowen Prison is a high-risk, maximum security prison established to house the worst adult male offenders in Victoria. For context, I'll provide a brief overview of the incidents leading up to our challenge and outline decisions of the court in our challenge and the more recent one launched by the Human Rights Law Centre. On the weekend of the 12th and 13th of November 2016, a series of incidents occurred at the Parkville Youth Justice Centre, which resulted in significant property damage at the centre. And on the 15th of November, 7 applications were lodged with the Youth Parole Board to transfer 7 young people to Bowen Prison. The Youth Parole Board rejected all 7 applications, and they referred to the criteria that was set out in the Children, Youth and Families Act that applied to young people under a children's court sentence as stringent tests protective of that age category. And the language is really important. Protective of that age category. It gives us an indication upon the very basis on which the Victorian youth justice system is predicated. Protection of young people, focus on rehabilitation and successful reintegration into the community. So hence, until recently, youth justice was the responsibility of the Department of Health and Human Services and not the Department of Corrections, which manages the adult justice system. On the 17th of November, 3 orders of council were published in the Victorian Government Gazette. And the practical effect of these orders was to excise the Grevillea unit at Bowen Prison and to establish it as a youth justice and remand centre. Over subsequent days and weeks, a number of young people were moved to Grevillea from Parkville and Malmsbury youth justice centres. On the 22nd of November, the Victorian Aboriginal Legal Service commenced a proceeding alleging that the detention of Aboriginal and Torres Strait Islander children at Bowen Prison was unlawful. And a week later, the Secretary of the Department of Health and Human Services undertook that she would not place any Aboriginal and Torres Strait Islander children at Bowen Prison for a period of 18 months unless in exceptional circumstances. So as a result, Aboriginal and Torres Strait Islander children being housed at Bowen were removed. However, there still remained in Bowen a number of other young people not of Aboriginal or Torres Strait Islander descent. Following a 4-day trial in the Victorian Supreme Court to hear the Fitzroy Legal Service challenge, Justice Gard issued a judgment on the 21st of December. And I won't go into too much of the legal argument, but essentially Justice Gard ruled that the Minister, when making the orders to establish the Grevillea unit in Bowen as a youth justice centre, did not take into account relevant considerations that were required to be taken into account by making that decision. And these relevant considerations included the purposes of the Act, the specific purposes of a remand centre and youth justice centre, the duties of the Secretary, and the entitlements of detained young people and how they would be met in the new location. Further, Justice Gard said, and I quote, "Essentially, the Department and the Minister were flying blind as to the real situation and suitability of the Grevillea unit when the orders in Council were made," unquote. Furthermore, Justice Gard said, quote, "When the Grevillea unit was occupied, the Department was quite unprepared to meet the demands on it to comply with the Secretary's duties or to provide young persons with their entitlements. It found itself on the occupation of the facility unable on the occupation of the facility to cater for the developmental needs of young persons, receive visits, or provide for medical or religious needs. It did not provide information to young people who had been relocated to Grevillea. No attention was paid to the form of protection, care, custody, or treatment that was in the best interest of the young persons transferred to the Grevillea unit." The Victorian Government subsequently appealed this decision and received a stay, arguing that there was no place to remove the children to. This meant that the young people had to remain in Bowen Prison until the appeal was heard. This was mid-December, which meant that these young people remained in Bowen Prison and spent Christmas there. Our clients described some of the conditions in the Grevillea unit at Bowen Prison to us. They were hungry. The food provided was not substantial enough. Dinner was served at 4 p.m. and nothing until breakfast the next morning. They had difficulty in accessing visits from family members. It was too far away. There was no public transport, leading to a feeling of loneliness and disconnection from their families. There was a lack of access to educational programs and recreational activities, leading to boredom. There was nothing to do all day. Remembering that these are teenage boys. The Court of Appeal, the Supreme Court, heard the government's appeal and made a ruling on the 29th of December that no error had been made in Justice Gard's finding that the Minister failed to take into account relevant considerations. It essentially upheld the initial decision. The Victorian Government then immediately re-gazetted the Grevillea unit, noting in their press release that the issues raised by the courts had been addressed in the new gazettal. This meant that young people continued to be housed in the Grevillea unit of Bowen Prison. The Human Rights Law Centre lodged a new challenge in 2017, with Justice Dixon of the Supreme Court ruling on Thursday the 11th of May that the Grevillea unit of Bowen Prison's reclassification as a youth justice and remand centre in December was incompatible with the children's human rights and to have their best interests protected. Due to this decision, all young people have now been moved out of Bowen Prison. The factors which led Justice Dixon to make this ruling were the impact of Grevillea's built environment on the youths who were children detained there, which was and remains that of a maximum security adult jail. The extensive incidence of isolation by lockdown for substantial periods of the day, extending up to 23 hours, in cells designed for occupation by adult men. The continuing use of handcuffing in order to move detainees between one wing of Grevillea and the outdoor exercise area. A failure to consider the heightened risk of detainees developing mental health problems directly relating to the environment in Grevillea, including depression, anxiety, cognitive problems, hypersensitivity and paranoia, or the exacerbation of existing mental health conditions. And the limitations on the developmental needs of detainees, specifically their physical, social, emotional, intellectual and spiritual needs that were affected by the use of Grevillea as a youth justice precinct. For the Fitzroy Legal Service's specific challenge, despite 2 Supreme Court rulings in our favour, it didn't achieve the desired outcome, which was to remove all young people from Bowen Prison. So hence the obvious question, what did we achieve with our litigation? In our view, regardless of the outcome, we shone a spotlight on the issues of young people in adult detention. We sought to provide a balance to the debate that was occurring in the media and the community about youth crime, the notion that youth crime was spiralling out of control, that we need to get tougher on young people, tough on crime. And whilst there was a lot being spoken about the young people in the youth justice system when they've hijacked cars or burgled homes or rioted, rarely had the voices of these teenagers or their families been heard. In our work at the Fitzroy Legal Service, we support defendants, victims and families. We have found a way to assist many different community members with a variety of legal issues. We provide assistance to young people involved in the criminal justice system and knew some of the individuals that had been moved to Bowen Prison from Parkville or Malmsbury. We certainly don't seek to downplay the seriousness of criminal offending that leads to our clients and other young people being detained in youth justice centres. What we do know, though, are some of the key factors that influence this offending. Children in the criminal justice system often come from very disadvantaged backgrounds and have complex needs. Many of these children have experienced trauma, family violence, child abuse, often resulting in them coming into contact with the child protection system and being placed in residential care. Many have a family history of involvement in the criminal justice system, a parent or a sibling who has been imprisoned. Many are using drugs. Food, education, jobs, structure, family, things that many of us take for granted. A lot of these young people don't have that on the outside. Some of them as young as 11 when they were first locked up. In response to the issues facing the youth justice system, an inquiry was launched by the Victorian Parliament's Standing Committee on Legal and Social Issues. Some of the young people being detained at Parkville Youth Justice Centre contributed letters to this inquiry, and 2 comments in particular stood out for me, and I quote, "If you grow up in a family or community where crime is normal and violence is normal, you grow up thinking that's what life is meant to be like. By the time you realise it's not, you're kind of already in that world and you're doing things that are really hard to stop doing," unquote. And the second comment, "You can use drugs and then you need money to get more, so you do awful stuff that you shouldn't. And then you feel ashamed of what you've done, and so you think it doesn't matter anymore. So you do more of the bad stuff that makes you feel shame, and then you end up in here," unquote. Most of the focus on the riots that occurred at Parkville in November was on how to deal with the individuals involved. The question that really didn't get asked was, why did the riots occur in the first place? The system had been going well for such a long time that it became neglected. Overcrowding, understaffing, and a punitive approach all fuelled unrest in the Victorian youth justice system. The sector lost a large number of highly experienced staff in the years following a public sector purge of jobs, and this led to a loss of expertise and people with that deep knowledge on how to work with troubled young people. Perhaps understandably, the response of frightened and under-resourced justice workers to challenging behaviours has been to resort to increased use of isolation and lockdowns. And overcrowding is not about more offenders being sentenced. Most of the new detainees in the past year were on remand. The uncertainty of being on remand generates great anxiety and frustration amongst young people. Aside from the overcrowding and staff shortages, those who have worked in the Youth Justice Centre for some time point to a shift in culture, to a more punitive and restrictive system within the centres at the expense of rehabilitation. There was a recent article in the Law Institute Journal that interviewed one youth justice worker who recently quit his position at Parkville. He says he originally applied for the job with the impression he'd be working in a therapeutic, social justice, social work type of role. That's what the advertisement said, but what I ended up being was just a guard. The issues around youth crime and the youth justice system are highly political. We have both the Victorian Government and the opposition trying to outdo each other in the tough on crime stakes. In the wake of the riots at Parkville in November, Premier Daniel Andrews said he and the community were sick of the disgraceful behaviour in youth detention. Those inmates will be going to adult prison, and I make absolutely no apology, he said at the time. And as reported in The Age on Friday, the May 12th, Opposition leader Matthew Guy agreed that the inmates deserved no apology for human rights breaches, saying the decision to put teenagers into the secure facility was the right one. One of our elected officials here in Victoria stating that there should be no apology for human rights breaches. You might start with youth justice, but where do you extend that line of thinking to? And if you think about the language used in media reporting on youth crime, child thugs, teen misfits, youth gangs, there is no doubt that media focus influences decision makers and the community. My dad is a prime example of the influence of media, proceeding to fortify his house in the northern suburbs of Melbourne for fear of the Apex gang, despite the fact that the family home has been untouched by crime in the 40 years my parents have lived there. Claims of youth crime wave must be kept in perspective. While police have identified a pattern of serious offending by a very small cohort of young people, youth offending is generally otherwise in decline. Compared to 5 years ago, there has been a drop in the number of children and young people under 18 engaging in crime. In the wake of the revelations about the Northern Territory's Dondale Detention Centre, a Royal Commission was established. And the former Northern Territory's Corrections Minister, John Elferink, told the Royal Commission that being seen to be tough on crime was a vote winner, despite the fact that there was no evidence that such an approach had any benefit. The media has almost exclusively framed youth as a justice problem, rather than a key element of our community's future success. Children's unique vulnerabilities have been overlooked in this debate, and their voices have been sidelined from the conversation. I'll now refer back to my original comments. As a society, we treat children under 18 differently to adults in a whole range of other areas: driving a motor vehicle, drinking alcohol, voting. So why should justice be any different? Those who agree that young people should be punished for their crimes and that an adult prison is an appropriate place to house them have an assumption that physical maturity signifies psychological maturity. You've probably heard this. These aren't young people or children. They are the size of grown men, so they should be treated as such. Adolescence is a critical phase of brain development. The rational part of a teenager's brain isn't fully developed and won't be until the age of 25 or so. And in fact, recent research has found that adult and teen brains work differently. Adults think with the prefrontal cortex, the brain's rational part. This is the part of the brain that responds to situations with good judgments and an awareness of long-term consequences. Teenagers process information with the amygdala. Sorry, I'm not a scientist. This is the emotional part. In teenagers' brains, the connections between the emotional part of the brain and the decision-making centre are still developing. and not necessarily at the same rate. As they grow, children develop the mental skills and the abilities they will need to function throughout their lives. Key capacities like the ability to focus, pay attention, and ignore distractions begin to develop in early childhood when they require plenty of practice and support, but they aren't completely operational until people reach their mid-20s. Brain development links to the assumption that crime is a rational decision, that young people weigh up the costs and benefits of committing a crime and choose their behaviours based on the likelihood that they're going to get caught. Hence, the conclusion for government and a lot of people in our community is that the only way to decrease crime is to make punishments harsher. Our juvenile justice system works like a maze, with many entrances but few exits, so youth get stuck in it. We need to redesign it with fewer entrances so we can reroute youth instead to more effective treatment options, like drug and mental health treatment. To ensure good youth outcomes that contribute to our community's safety and well-being, we need practical juvenile justice policies and programs based on proven, age-appropriate interventions, which may include detention as a last resort, but it must be an age-appropriate detention facility. We know that adolescence is a time of rapid brain development, which affects youth's judgment, decision-making and behaviour. For that reason, it makes no sense to treat youth as adults, including placing them in an adult maximum security prison. Instead, we can achieve better outcomes by keeping children and teens out of the system through diversion programs, mental health treatment and other interventions, practices that are both feasible and in line with modern understanding of adolescent development. In the recent Victorian State Government budget, $288 million has been allocated for a new Supermax youth justice system. This was a missed opportunity to create a world-class youth justice system that reduces disadvantage and ultimately keeps the community safe. $288 million for a 224-bed Supermax facility. You do the maths. That's over $1 million per bed. Is that really money well spent? Where are the dollars for initiatives that actually have been proven to work? Thank you.